Thank you so much.
Great, thank you. And thanks everyone for reconvening here after lunch. Some of you I know were here last year and have participated and been able to ask questions of this group previously. I'm thrilled that we were able to reconstitute the group this year and very happy that Brad Smith is able to join us as the director of OFAC. So we'll be able to hear both from the US and the UK perspectives of the regulators. And then Marlene and I will add some questions and context and perspective from the private practice and sort of industry perspective as well. We tend to be, and maybe if you remember this from last year, we tend to be kind of a conversational group and are happy to have this be a bit more of a discussion. Everyone on this panel could talk about sanctions for 12 hours a day, and we actually do. So we can go off on some tangents, but we're happy to, and happy to sort of go where your questions might lead as well. Just as some kind of opening context remarks, I think last year when we met, we had a lot to update on as far as, in particular, US and UK and EU coordination and alignment and partnership on implementation, both from a targeting standpoint and an enforcement standpoint on economic sanctions. And so now here we are, 12 months later, and I think some of those initiatives have had some time to crystallize a bit more. So I'm just thrilled that we have the group here to update us and give us some perspectives. And just really quickly to run through some short bios, and then I'll have some opening comments from the folks on the panel here. My name is Bombach. I chair our international trade practice in Greenberg Trarig's Washington, D.C. office. And economic sanctions is bread and butter for me, both from the sort of general consulting and compliance, discrete compliance questions standpoint, internal investigations, working on settlement discussions and voluntary disclosures and enforcement cases in front of OFAC. So I'm happy to be here, and really for those of us in the sanctions space, I think historically this maybe has felt like a bit of a niche area, and for all the wrong reasons, this is now sort of a front page topic, but I think it's a great opportunity to have the discussion and also think about the different threads where the sanctions topics are intertwined with other regulatory and enforcement spaces. So to my left, Brad Smith, who in your agenda and the materials from the event is noted as the Deputy Director of the Office of Foreign Assets Control and the U.S. Department of the Treasury. As of September is now the Director. So we're hearing from the top here. And so we're happy to have Brad with us, and I understand that Brad and Giles have been able to take advantage of the proximity for some more formal working sessions as well. So Brad, thanks for being here. And then we've got Giles Thompson, who serves as the Director of the Office for Financial Sanctions Implementation and Treasury. He's responsible for AML, CTF, and financial sanctions policy, and the implementation and enforcement of financial sanctions in the UK. So we'll get to hear from the UK perspective and also about the partnership and coordination between the US and the UK with Giles and Brad. And then to my left, far left, Marlene Veldhuis heads the Dutch Corporate Crime and Investigations team at Loyens and Lof. Okay, I'm working on my Dutch. In Amsterdam, and she advises financial institutions, accounting firms, and companies on compliance with the anti-money laundering legislation and economic sanctions regulations. She also assists corporates, directors, and managers in the context of criminal investigations, including in cross-border corruption cases, tax fraud cases, and environmental law matters. The last note program note, unfortunately, Kateryna Gupalo from Arzinger in Ukraine was unable to join us today. She sent her regards, and for those of you that were here last year and were able to hear her comments about the important and positive impact that the sanctions have had in Ukraine, I'll just reiterate those on her behalf. So with that, I will stop talking, and we can hear from Brad and Giles and Marlene on some context on economic sanctions, and then where we see things going. So Brad, I'll pass it over to you.
All right.
Thank you.
Well, first of all, I just want to thank you all for being here. As Kara mentioned, sometimes sanctions historically have been viewed as a bit of a minute or indiscrete practice area, but over the last 20 years, I'd say it's expanded some, which maybe for law firms is a good thing, but sometimes can be frustrating, I know, for the community that we have to regulate. But part of the reason I'm very grateful for you all to be here is we're also acutely aware that when we impose sanctions, we ultimately are putting a big burden on the private sector. And that any compliance with sanctions is ultimately a partnership between both the government that intends to impose the prohibitions and the parties that are on the front lines of implementing them. And often, in my experience, that means the compliance offices at various firms and entities around the world, as well as their lawyers, who sometimes are charged with the challenging job of trying to decipher prohibitions that we may have put in place without full insight as to how they might be interpreted or implemented in the private sector. Now, I think a lot of folks here are familiar with what sanctions are and who they are, but just by way of background, very briefly, the office I had has been part of the U.S. government for about 80 years now. We were stood up on the eve of World War II as part of an operation to protect Danish assets that had been overrun as the Nazis began their invasion across Europe. And over time, with a little bit of change, we have more or less been part of the U.S. government. We have fluctuated in size to a high of about 500 people around World War II, to a low of about 35 right before 9/11. And since that time, we have ramped back up to where we're about an office of 320 or so lodged in the Treasury Department, that with our colleagues at the U.S. State Department and the U.S. Commerce Department, as well as the Justice Department, help design and implement what we call economic sanctions. Now, sanctions have been in the news quite a bit over the last 10 or 12 years for a variety of reasons, none of which are probably good, but they reflect the fact that sanctions ultimately are a tool of policymakers. And at a very conceptual level, sanctions are designed to impose economic cost on both our domestic population as well as an international population in an effort to try to change behavior by a regime or individuals that we think are undertaking activity that ultimately undermine our common values and our national security priorities. In particular, for better or worse, over the last 9 years, sanctions have evolved to focus on various nefarious activities undertaken by Russia. We stood up what we might describe as our modern sanctions regime against Russia in 2014 with the incursion into Crimea. And then in the United States, over the last 9 years, modified those authorities to address a number of additional threats we saw from Russia, including malicious cyber activity, electoral interference, and numerous activities we saw with other sanctions programs around the world, including places like Venezuela and transnational criminal organizations. But of course, over the last 20 months, we have really ramped up our sanctions to focus on the sad invasion of Ukraine. And it's important, I think, for us as Americans to come to London to take on this topic, because conceptually, I think sometimes oceans have always separated the United States, and that can, in a way, put physical distance from the actual threat that's at play. Kyiv, for instance, is closer to London than Denver is to the United States. Los Angeles is 1,000 miles farther from Washington, D.C. than Kyiv is from London, which is to say we know this threat is very real and it is very acute. People here probably see it and feel it more than some of my compatriots back home. And we are conscious that those of you closer to the front lines are perhaps most acutely aware of the threat. But very briefly, when you look at the Russia sanctions program, one thing I would encourage you all to appreciate, and perhaps you feel already, is its nuance. If you're a sanctions nerd like me, what's fascinating about Russia is it pulls in a number of different ways in which we've deployed and used those authorities across a number of programs. First of all, it has an element of what we would describe in the US as full blocking, a full embargo. We have walled off certain parts of Ukraine, like Crimea and current occupied regions, to say US persons can do no business with anyone in that region whatsoever. We have deployed what we call our targeting authority to go after and hit individuals who act in certain sectors of the Russian economy. We have prohibited new investment. We have imposed more broadly direct import restrictions as well as direct export restrictions on citizens in the United States. And we have tried to work with our European and other allies to develop a multilateral program designed to leverage not only US authorities and US power, but the world's combined power. Because in a lot of ways, even though a regime like the United States can impose sanctions, we're very conscious that they are most effective when they are undertaken in a multilateral way. And what we've seen, for better or worse, with Russia's invasion in Ukraine is in that horrible situation that has forced us sometimes to break down bureaucratic walls and challenges that existed before that attack. Most notably, I would say it sort of harmonized in ways we hadn't seen, with one or two exceptions: the United States, the EU, Britain, and some of our allies in the East. In addition, internally, and this is something that those of you who've been in government can probably appreciate, Russia forced us to break down bureaucratic hurdles that had existed and complicated our effort to harmonize action. Within the United States, for instance, we at the Treasury Department have undertaken a number of efforts with our colleagues at Commerce and Justice, as well as our Homeland Security Department, to come up with clear, or at least we hope clear, probably a better description, guidance to the public. Going forward, I think we're hopeful that those lessons can lead us to a better place where we can develop more coherent and more effective regimes. And the final thing that I think it's probably forced us to do is to engage more directly with the private sector as we're developing and then implementing sanctions. Within the United States, for better or worse, our sanctions authorities are undertaken without public notice. That's because, if you think about it, we don't want the assets to flee the United States before we act, because we want to immobilize those assets to then use them for leverage or perhaps as a way to sort of buy a piece that we haven't been able to obtain. But the complicating factor of that is it often means we in Treasury, as much as we may understand sanctions, do not fully understand at the outset how they may impact the private sector. We may not fully appreciate the terminology and the ways in which it can be misconstrued. Over the last 20 months, we have set up a number of channels for direct dialogue with financial institutions in the private sector. And going forward, that is something I think we all collectively hope we can continue, because it certainly is easier, I think, on the private side, and certainly better from a public perspective when we're able to communicate. And the final thing I would just stress, particularly where we are, is it's been sort of our great pleasure to use this event to sort of further our already deep relationship with the United Kingdom. For those of you who are in government can appreciate it. For those not in the private sector, let me assure you that the phrase special relationship, the Roosevelt-Churchillian relationship of World War II, very much carries forward from at least the US perspective today. When we talk about the UK, we ultimately know we have a tough partner. It's one who, even when we disagree with, we can speak candidly with. And as part of that, Giles and I, and my predecessors there, Andrea, have been able to work up a partnership where we're exchanging personnel. We've set up opportunities where we're able to meet with each other in London and in DC, and then have a number of virtual exchanges throughout the year. And that is something we deeply value, because although we certainly are going to have at times differences in how we approach issues or how we might lay it out, the common cause that we have is something that is very heartening and something from a government perspective that we deeply value. And I should stress we've also seen that increasingly with the EU, in particular with the Dutch in the EU, in the partnership there. And that too is something that this has provided, in as sad a way it is, an opportunity to further develop. So with that, although as Kara mentioned I could babble on forever, I will cede the floor to our host at the government and someone that we all deeply respect, Giles.
Thanks very much, Brad, and thank you for inviting me to participate in your conference again. It's fantastic to be here. I think last year, Brad sadly couldn't join us because he'd been struck down by COVID, and I have to apologise in advance if I have a coughing fit. I've had a bad cold, which I'm now getting over, but occasionally lapse into coughing, so apologies if that strikes me. Perhaps when I get a difficult question, it will be my escape valve. But just to add, Brad's given you a really good comprehensive overview, but just to add a little bit from a UK government perspective and provide a little bit of a backdrop and history for my office, the financial sanctions implementation in His Majesty's Treasury. So the Treasury has long had a function, not quite as long as OFAC, but long had a function to implement financial sanctions, but it only really stepped up and clicked into gear with the establishment of what we call OFSI, the Office of Financial Sanctions implementation in 2016, which was born out of a decision in the UK government that they needed to take financial sanctions as a tool, as an economic tool, more seriously. That's to say, we needed to get better at explaining it and helping the private sector implement it and provide a better service to them. As Brad says, we don't freeze anything, we don't implement anything in OFSI, it's the private sector who do that. So our sanctions are only going to be as effective as how well they're understood and implemented out there. So we wanted to get better at providing that guidance. But we also wanted to toughen up how we enforce it, and I think that's born out of a wider realisation that those of you who follow UK politics and UK developments closely or are based here will recognise over the last few years, I think, a growing determination in the UK government that sort of perceptions of London as Moscow-on-Thames or whatever it might be as a soft spot for illicit finance aren't good for UK prosperity, they're not good for UK competitiveness, and they're not good for UK national security ultimately as well, and that these actually work together. It's not a trade-off. If you toughen up on sanctions and money laundering, you're going to damage competitiveness. Not at all, the opposite. You'll make your city, you'll make your financial sector a more robust, a more attractive, a more desirable place to do business ultimately. So OFSI was born in 2016. We've grown. We were about 35 people pre-Russia-Ukraine crisis. We're now well over 100 people as a result of that. And not only have we expanded, but we've tried to dramatically change the way we do sanctions, partly out of necessity because of the demands of the Russia crisis, but also out of a desire to be more effective in how we implement sanctions and enforce sanctions. So I think that journey has also come on the back of, obviously, since 2016, we've also undergone a massive change in our legal basis, our operating basis. Previously, all financial sanctions, all sanctions in the UK, pretty much derived from the EU, from the European Union. Post-Brexit, we had to put in place an entirely new autonomous legislative regime to implement sanctions in the UK, which is in our Sanctions and Anti-Money Laundering Act. So that was a major focus of the last few years. In terms of the Russia-Ukraine crisis, I think just a few additional points to add to what Brad has said. I think this has certainly been the most extensive, far-reaching, complex sanctions regime we've ever implemented in the UK, and I wonder probably ever been implemented globally, although I'm sure some history buffs out there will correct me if I'm wrong, some sort of League of Nations era regime or some such. It's in terms of putting sanctions in place. Previously, our biggest regimes were Libya, Iran, DPRK probably. The Russia sanctions are far more extensive than that, both in terms of numbers of people and entities listed, both sectors as well. We've expanded into trade sanctions in a way we never had before. So a whole new legal services in the UK, for instance, provided to Russia, now called auditing services, consultancy services, IT services. I think, in terms of scale, over 90% of UK trade, both ways with Russia, is caught by export prohibitions one way or the other. we pretty much sanctioned every major Russian bank out there, a number of major oligarchs. We've got over 18 billion, I think, at least latest count, pounds frozen in the UK from Russian entities under the Russia regime, which surpasses Libya, which was previously our biggest regime for frozen assets. And the complexity of these sanctions has really been striking as well in the scale of economic ties between different countries, corporate transparency or lack thereof in Russia that's made it incredibly difficult often for the private sector to disentangle who they're doing business with, who ultimately owns companies, and so forth. And the degree of international alignment that's necessitated has been massively striking. Of course, we always coordinated with our US partners, with our European partners, with our global partners, but in order to have maximum impact of the Russia sanctions, and in order to ensure that they've been as effective as we think they have been, has really made us step up our game. And as Brad and Cara said, it's fantastic that Brad has come over both for this panel, but we're also using it for another couple of days of meetings to further the partnership that we've established. It's hugely valuable to the UK in helping us develop our capability and working collaboratively with OFAC. And there are areas where we remain unaligned and work for us to do undoubtedly, but I think we've come a long way in trying to designate the same people and entities at the same time in terms of harmonising or aligning our licensing regimes, in terms of cooperating on outreach to industry. Brad and I are doing a big private sector event here in the UK tomorrow with our industry jointly as an example of that. More to do, I think we've come a long way. And I think that's shown in some of the impact. I think it's important to bear that in mind, and it's a shame Kateryna can't be here to give us a little bit of a taste of how it feels in Kyiv, which I hope will be recognising the role that sanctions have played in the effort against Russia. Obviously, military support is a massive plank of what the West is trying to do, but President Zelensky downwards, I think the Ukrainian government has talked to the value of the sanctions in both, in the short term, reducing Russia's economic growth below what it would otherwise be, constraining their revenue to fund the war effort, and obviously energy revenues have kept that more buoyant than we would have liked for the oil price cap implemented by the G7 and a couple of other partners is a great example of some of the more innovative tools that have been deployed in an effort to constrain Russia's revenue. And I think you can look at the figures, the dent to Russian growth, the dent in Russian revenue, struggles accessing foreign reserves through the very innovative central bank of Russia measures that we took. But actually, a lot of this impact is going to be in the long term, constraining Russia's ability to be a threat to the West in the long term, to prosecute the war in the long term, as they really struggle to get access to sensitive parts, critical parts, financing, brain drain from people leaving Russia, all as a longer term impact of our sanctions. So I think, looking back now finally, from when I did this panel a year or so ago, I think increasingly now we realise these sanctions on Russia, are here to stay for the foreseeable future in one way or the other, unless diplomatic development surprise us on the upside. So, I think we're in a sort of slightly different phase of starting to plan for the longer term, learning some of the lessons from the Russia crisis with an eye on future crises that may necessitate the deployment of a similar toolbook, and thinking about what we've learned and what we can continue to do better. I think Brad mentioned making sure that we're mitigating some of the consequences that sanctions can have on the private sector, on the humanitarian sector, trying to do that better, working on continued alignment, but also learning some of the lessons of working better with the private sector. And for me, a part of that is sort of mainstreaming sanctions for the longer term into the more prominent position it's taken on within government, but also within the boardroom and the private sector and compliance in the private sector, and making sure it stays there as a priority for the foreseeable future. But look, I will stop there so we can get into more of that dialogue and pass on finally for that important private sector perspective to Marlene.
Thank you so much. Thank you also, Karen, for being here. Yeah, indeed, as they mentioned, it was a very complex legislative framework that we have seen. We have seen a lot of sanctions imposed, a lot of people sanctions, company sanctions, and different topics were included. And after that, we of course have seen a lot of compliance questions coming our way. Sort of a storm of compliance questions, I can say, and that continued for several months as the sanctions packages continued to renew itself. We have seen a lot of questions on how to deal, especially with the European companies, European subsidiaries of Russian companies, but also European companies with UBOs on the sanctions list. And not only like during the start, but we have also seen, of course, that UBOs changed after sanctions were imposed. We have seen that ownership transferred, for example, to wives of the sanctioned individuals, to children of them, to business partners, and a lot of questions then, of course, arose: how do we need to deal with those companies? And especially with those companies who were there normally to stay in the Netherlands, just regular companies, but then owned by sanctioned entities, or then after the changes, no longer owned by UBOs who are sanctioned, but new individuals, with the question: are they indeed now being owned by people who are not sanctioned, or actually still under the direct control of sanctioned individuals? So we had a lot of questions how to deal with that, and the question was whether can we still continue working with them? How do we need to look at, for example, real estate provided to those companies, rent, can we continue to rent the leasing agreements with those companies, or do we need to stop that? But if we were to stop those leases, and then they can continue to work from out these offices without paying even the rent, is that not indirectly beneficial to the UBOs who are sanctioned? So a lot of, for example, also practical questions that arose following those sanctions imposed. But what we also have seen is the difficulty in how to explain those sanctions. Not only like the easy sanctions, like we cannot provide direct funds to them, but what does indirectly mean in this context? How do we need to look at that? But also the prohibition, for example, to transfer funds, but to provide or sell certain assets, not only, for example, to Russia, but also for the use in Russia. How do we need to deal with that? How do we need to control that we make sure that if we sell something to a company, it doesn't end up being used in Russia? And for the large quantity of rules and regulations made it very difficult for companies to comply. So we received a lot of questions. Of course, everyone was aware of the reasons. Everyone knew, okay, we need to follow the guidelines, but also the guidelines were not clear yet. Especially in the beginning, the sanctions packages were much faster than the compliance guidance provided. And we have also seen that there were some differences. We heard about the alignment. It was indeed a very aligned approach, but there were still some examples of UBOs not on the list in the EU, but were on the list in the UK, or the other way around. How do we need to do with that? If we are a global company, do we need to stop working with them? Do we need to continue? How should we follow up on that? And also, if we wanted to ask for compliance advice or some guidance in the Netherlands, they were quite willing to assist us. For example, the Ministry of Finance in the Netherlands was quite willing to provide us some more information, some more idea, but every time under the very important mention that there is no Dutch guidance on European regulations. You need to look at European guidance. And well, in the meantime, they were very helpful when asking questions, but still it continued to be a struggle for the companies who tried to do the right thing. At the same time, we also saw some early enforcement actions. The Dutch public prosecutor was very involved, and already closely after the first sanctions, they froze some accounts of an entity which was sanctioned after a financial institution failed to do so. They also then immediately published a press release showing how good they were working on the sanctions. And I think that had a great impact in the Netherlands and in the compliance field of the Netherlands, because everyone was aware it's not only the need to make sure that sanctions are being followed because we want to avoid violations and we want to avoid helping people in Russia, but also the real deal that the Dutch public prosecutor could come by every minute to discuss. And if we look at the recent developments, we have seen since 2022 that the Dutch public prosecutor started 45 criminal investigations into violations of sanctions regulations and suspected circumventions of sanctions regulations against Russia. So you can see that it's an ongoing point of attention for everyone in the Netherlands. But I looked around and asked around, and we see the same developments going on in other European countries, although they are not that keen on as the Dutch to publish on the enforcement actions being taken. I think that they will wait for the court cases to show what they have been doing all those time.
Great, thanks. So I'll make a couple of comments, just picking up on some of the themes here, and then I have a bunch of questions for the folks on the panel, and I'm happy to even open it up early as we're kind of going through the discussion if folks in the audience would like to inject some questions. But I think both Brad and Giles have commented on the nuances, the complexities of the sanctions regimes. And I would say it's not unique to the Russia sanctions. I always think about the different regimes as sort of there's a shopping list or a laundry list of different measures that or levers that could be invoked by the regulators. And certainly from a private practice perspective, I think where there's alignment, just using the example of the US regulations on Russia, it is a patchwork quilt. That's sort of how I think about the sanctions regimes. And if we think of the UK having its own patchwork quilt, maybe we line them up and there's some better alignment. Certainly from a practitioner and an industry perspective, those every place where there's alignment. First of all, I think from a foreign policy perspective, it makes the sanctions more effective, as you noted. From a practical standpoint, it makes compliance and implementation somewhat easier because we have less in a game of whack-a-mole, we have less moles popping up because we can see that these are, I don't know, what's the equivalent? What's the British?
No, we use
whack-a-mole. Okay. Didn't want that to get lost. Okay. So in that sort of, trying to isolate where the distinctions are and where there might be either a lack of clarity or maybe actually contradiction in approach, that certainly makes it easier. And so I would just like to say I appreciate that, and I think that the joint publications that have been coming out are also helpful because it is obvious that there is alignment, and the sort of linking up of the agencies at the governmental level. But then, of interest, I think, to the audience in this room, when we see that sort of enforced and increased coordination on the implementation side, I think we have to expect that we're going to see it on the enforcement side as well. And so I think that's something that would be interesting to hear from Brad and Giles about Certainly we have observed increased coordination even within the US government, like you said, Brad, between DOJ, other offices of Treasury like FinCEN, State Department, Office of Sanctions Coordination, but to understand, is economic sanctions the new FCPA from a sort of global, coordination and multilateral enforcement perspective would be interesting to hear.
Well, I'll offer just a couple of thoughts. I'm curious if Giles may have different views. I think the way I think about it is there's more than enough work to go around in this space, unfortunately. And in enforcement, I would think of, and we talk about it, at least domestically in the US, as sort of having two elements to it. On one side, there's enforcement in the sense that if you are supporting someone who we have sanctioned, we may come after you. We may come after you by designating you. That is, by imposing sanctions on you and effectively cutting you off from the US financial system. We can do that whether or not you have a presence in the US. And then second, we can also try to pursue what you would think of maybe as a more traditional enforcement posture. That is, to pursue, perhaps with our justice colleagues, criminal action, but more commonly in the sanctions space, particularly against entities that by and large want to be compliant, a civil enforcement action. And for that, we have to have a jurisdictional hook, and so you need to have a presence. Usually, depending on the case, it will vary, but a lot of times it would be because the transaction is what we would call dollarized. It comes through, perhaps even briefly, just through Manhattan and some of our New York banks. And that gives us a hook by which we then can pursue the actors. That involves a lot of different authorities within the US government. And one of the things we often get complaints from is a violation, particularly by a financial institution, could trigger, and in fact has triggered, instances in which there's upwards of 5 to 7 different US entities that are bringing action. Sometimes you may even have, if you're a financial institution, both federal regulators, OFAC, Department of Justice, Federal Reserve, which you could call a regulator, and then domestically, depending on how it's chartered, New York state authorities, and that can be really complicated. But then internationally, I think what we also are trying to do is build a partnership where we have a better understanding as to how some of our allies look at sanctions, what their authorities are to bring enforcement. And then we can educate each other as to how we develop those cases and how we pursue them. Within OFAC, we close about 1,000 enforcement cases a year. Most of those aren't going to be public because a lot of times when we think of enforcement, what we're really just trying to do is encourage compliance. We'll push out anywhere from 12 to 2 to 3 dozen public cases that may involve billions of penalties a year, but those are rare. We will also initiate a number of investigations through issuance of subpoena, informal requests for information. Those are also enforcement actions. They may not be public. They may take time. They may involve engagement. And there may be a lot of back and forth with the private sector. And so that's something I would think about, too, in the enforcement space, that it isn't always going to be a public action. And the third thing I would say is enforcement, I think, also has to be thought of as not necessarily just that we're going to bring a hammer. Within OFAC, we engage in more than 200 different outreach events a year to both domestic and international audiences. Because the ultimate objective for us from enforcement, as I mentioned, is compliance. And you can only do that through education and through an exchange. And part of that is by trying to ensure you all that when you see something, even if it's a technical violation, it's not necessarily, in fact, probably won't be our posture or desire to necessarily hit you with the biggest penalty that we could muster under the statute. It's often wanting us to hear about it, to understand what's going on, so that we can figure out down the chain who the bad actor is. And when we identify who the bad actor is, who may have duped your company, who may have misled somebody, that may enable us to take action. It may enable us to pass information to Giles' office so that they can take action, or it may allow us to leverage other law enforcement colleagues, Europol, and other places where they can do something. And so the plea we make to industry often and in these settings is really to try to encourage you all to reach out to us where you think something might be at play so that we can try to suss it out and have a candid exchange, but with the assurance that if people are acting in good faith, unless it involves circumstances of what we would describe fairly egregious, i.e. willful, grossly negligent behavior, we probably aren't going to be coming after you looking for a massive, hefty penalty. And even if it is, we're probably going to be able to figure out ways we can mitigate and to design it in a way that's more effective going forward.
Yeah, no, I mean, very similar in the UK in terms of approach, although I think we're in the earlier stages of developing our enforcement toolkit and history, because obviously only actually took on, acquired the legal power to issue civil monetary penalties, fines, a few years ago. Previously, we only had criminal sanctions in the UK. Just to provide a bit of context, so as in the US, where DOJ traditionally would do the criminal investigation, prosecution for sanctions offences, in the UK, it's the National Crime Agency who has that responsibility. So my office has just got civil powers. So our primary objective is to help people comply and avoid having to use these powers. 95 upwards % of cases we look at don't end in a public enforcement action. They end in either us finding that there's no breach in that case, or that it was a very low level breach, there were mitigating factors, and we're not going to pursue further action. We might write a warning letter to the company involved. We might meet with them to explore, find out what they're doing to improve their compliance systems, to learn the lessons. But what we find is the vast majority of business want to comply, they want to implement sanctions, and as Brad says, we're not going to come after people with a sledgehammer who are seeking to do the right thing, who are notifying us of anything suspicious, and who are trying to put in place appropriate risk-based compliance system, and that's set out very clearly in our guidance. That said, where we do take enforcement action, it's important that there is robust enforcement action in any regulatory system, as you know. We will target that on willful cases of evasion, where people are knowingly seeking to avoid or circumvent our sanctions. Quite often that would fall into the criminal side of things in the UK, although there will be cases that will be pursued either in parallel or from a civil perspective for various reasons. Obviously, there may be cases where international partners are better placed to act, in which case, one of the things we're trying to do through our partnership is improve our information sharing to ensure that we're giving each other the right information on those cases. Or there may be other tools at our disposal. It may be that actually pursuing a money laundering offence or another offence is a more appropriate avenue to explore. But where we pursue action, I would just highlight a couple of things. Firstly, since the Russia-Ukraine crisis, we've taken on a couple of changes to our enforcement regime. So previously, effectively, we had either engagement with a firm, a warning letter, or we had a fine. We've now taken on an additional ability to issue what we call a public disclosure. We did the first of these 3-4 weeks ago now. You can find it on our website if you Google it. It related to a payment provider called Wise. So this was an offence of breach of current post invasion of Ukraine, Russia sanctions by Wise that we didn't deem sufficiently serious to issue a fine for, but we did issue one of these new public disclosure notices because we felt that it was sufficiently serious, it warranted public enforcement action, and most importantly, actually, we thought there were some valuable compliance lessons to be learned in there. So, we do encourage people to read the compliance notice, particularly around, the importance of having a robust risk assessment in place to evaluate your exposure to Russian sanctions, but also in taking prompt action where you do identify a designated party and a sanctions breach. And I think, excuse me, the primary reason why we took action in this case was quite a long time frame between Wise becoming aware that they had continued to make a debit card available to a designated person, allowing them to withdraw money, and actually taking action to close that. And then the other big change in our legal framework has been to move financial sanctions, civil cases, to a strict liability test, as in, I think, in the US. Previously, we'd had a reasonable cause to suspect legal threshold, and we wanted to move to something which gave us a sounder footing to take action, but we have made it clear in all our guidance that isn't going to be an excuse to go after anyone for any little failing, despite their best efforts. It's very much going to be taking into account the compliance system, the efforts that the firm has involved to take action. We've done about 8-9 monetary penalty cases. So, I think our caseload is less than what Brad referred to. We probably deal with low hundreds of cases a year, with that numbers growing. Only a handful of those would result in public enforcement action. Actually, the wise cases are only public enforcement action from off-sea, directly related to Russia's sanctions since the invasion. We've got a number in the pipeline, so to speak. These things take time to work through the system. For the most serious cases, that's definitely the case in terms of length of gestation, so watch this space in the future.
Great. Well, Giles, I'm pleased that you brought up this liability standard, because I have just made a note to myself to throw that in the mix here too. That I think it's important when we're thinking about sanctions risks and whether we're helping companies with conducting risk assessments or compliance assessments or training or just counseling, just to understand how low the bar really is for inadvertently engaging in conduct that violates the various sanctions measures. And also from the US side, I believe this is the same in the UK and the EU, there's no de minimis dollar threshold or value of a transaction. So as Giles mentioned, I think that particular case was actually a fairly low value transaction, but the conduct was problematic. So I think that in some ways that increases the challenges on a compliance standpoint, but at least knowing that the treatment and the perspective is the same. I think historically on the U.S. side, from a private practice perspective, the threshold for what is a violation or is not a violation, as I said, is quite low. But all of the sort of compliance measures and best practices, and in fact I think back in 2018 when OFAC put out guidelines on best practices in economic sanctions compliance programs, all of those things that go to show your, attempting to prevent, making risk-based approach to the compliance program, and have some internal controls in place to detect and sort of deal with violations as they might happen. All of that goes a long way in those discussions with Brad and his office to say, look, we're making best efforts, things still slip through the cracks, here's all the reasons why, we don't think this merits any sort of civil enforcement penalty, and certainly not a criminal referral. But I think that, that now maybe is a space for greater alignment between the US and the UK approach as well. So one question just to bring Marlene in on the kind of the compliance perspective and the compliance program. I know, one of the particularly hot topics and sort of keywords, if you're looking at sanctions evolution here over the last 12 months, are circumvention and evasion. And I think that creates kind of an interesting touch point between this concept of strict liability and something that rises to the level of circumvention or evasion, which sort of implies a greater level of intent. And so, just understanding if there are some best practices or maybe specific things to look at in conducting risk assessments or developing compliance programs to sort of, as much as possible, put a mechanism in place to prevent anything that could even look like circumvention or evasion?
Yeah, that's a really good question, and I think it's good to also then touch upon the proposal of a directive on criminal offences and penalties violating union restrictive measures, because that one is being prepared. There's a draft legislation that was published in June of this year. And in July, members of the Committee of European Parliament published a proposal with amendments, and that included for several violations that there should be a possibility of criminal sanctioning of those violations, because currently there's a difference between the EU member states, where some have very harsh measures and criminal possibilities to impose. In other jurisdictions there has not been those possibilities. And there's a risk of foreign shopping, where bad actors conduct their behavior in countries where there's a low risk of criminal sanctions, or if there are criminal sanctions, a low risk of penalties imposed. And interestingly, in that legislation, it is said that you should add minimum sentence requirements, for example, a minimum of an imprisonment sentence to individuals, but also a minimum sentence of fine to corporate entities. And that applies even to jurisdictions where we don't know the concept of corporate criminal liability. Those should have sanctions to be imposed, then non-criminal sanctions to be imposed for at least a maximum of 5% of the annual turnover as a maximum fine. There are no minimum sanctions imposed. Members of European Parliament actually said we need to increase that to 15% of the annual turnover, which means that's a very high, significant number. And the reason why I would like to mention is that proposal for the regulation also includes specific examples of actions that will be regarded as circumvention. Because currently we have like knowingly and intentionally acting contrary to the restrictions imposed by European sanctions. So there is a very clear knowing and intention. Which helps, of course, when setting your compliance framework. But the proposal includes examples of circumvention, which will qualify as criminal behavior, and it includes, of course, transferring funds to or from a designated person and concealing those funds. That's of course obvious. But also it includes providing false or misleading information to conceal the fact that a designated person is the UBO of the funds, so the information provided. In addition, it will also apply to companies who fail to comply with an obligation to provide information obtained in the performance of a professional duty on forms of funds or economic resources. So you can think about financial institutions needing to report that they froze funds of a sanctioned UBO. If they fail to do so, it could be regarded as circumvention as well. But also reaching or not fulfilling the conditions under authorizations granted by the competent authority to conduct activities in which, in the absence of such authorization, are prohibited. So you can see that currently we have a lot of debate about what is circumvention, knowingly and intentionally acting contrary to sanctions obligation, and then you can think of a lot of situations in which you know or are aware that eventually, for example, funds or certain goods end up at a Russian entity or a Russian UBO. So that seems very clear-cut, but it will be changing in the near future. And when thinking about your risk and your compliance program, I would always advise the companies and the compliance officers involved to not only think about like the very obvious situation, but also to think about the future situation which may fall under the criminal obligations, so to speak. And currently, the most important thing is to make sure that you have like a very well-written risk policy, and when deciding to certain transactions, you have a very systematic approach in determining whether or not it could be regarded as circumvention, and why in this regard it's not circumvention, but it's actually a decision, a transaction which is allowed. And that's where we see the most failures in practice. People just discussing, debating, can we do this, can we do this transaction, can we move forward, having a great meeting saying, okay, we continue, and failing to make sure that it's all recorded in their administration. So that's the main point of attention there, but also looking then in the near future, what would be regarded as circumvention, which is much more broad than it's currently the case.
And it's interesting too, I'm just thinking through the additional complexities of these provisions that rely on or are triggered by the sort of UBO information, and particularly in light of the fact that in the Russia case, Russia introduced countermeasures, I believe it was last year, and some proposals for legislation in Russia, as if it was not difficult enough to research corporate registry information for Russian-owned or entities, or where Russian individuals were at the top of the UBO structure. The countermeasures that Russia implemented actually prohibit Russians from disclosing UBO information in an effort to sort of obstruct implementation of Western sanctions. So that just adds a whole other level of challenge, I think from the compliance side. Brad and Giles, I don't know if you have any comments specifically on the circumvention topic or things you think you
Well, I would just offer that in some ways it's a new challenge, but in many ways it's not. If you think about, a lot of firms have been dealing with know your customer, AML compliance issues for years and years and years. And a lot of those rules of thumb, I think, continue to apply. From a purely sanctions perspective at Treasury, we don't, as Kara mentioned, mandate any particular requirement. We just require that there sort of be reasonable due diligence, and that's going to depend a bit on the industry and the risk you're going to confront. I think a good rule of thumb is to always ask questions to get as much information as you can up front, but also recognize that where there are gaps, we're not looking to necessarily hit you. A lot of things I think from an evasion perspective are things that you've seen before. A lot of shell companies, a lot of structuring of transactions that look unnecessarily complex. It can be as minute as looking down and seeing sort of in the bills and exchanges that suddenly that you have a strange email address being used for part of the transaction. Do you have, for whatever reason, a company reporting that it's in one jurisdiction, but its IP address is showing up in another? Now, there's good explanations for that sometimes, but it's important to ask the question, particularly as we move increasingly to a complex fintech-based economy. So those are the things that I would just sort of encourage, the normal asking of questions. Bigger term, I think, from an evasion perspective, from our perspective, as mentioned before, we're not worried necessarily about the company that's duped, even though they might be, as Karen mentioned, subject to strict liability. We're worried about the network that's doing the duping, and that's what we want to disrupt. And so that's why, again, to go back to the theme we've touched on already, I really just would encourage you to come into us to the extent you see something suspicious. And that also can include, we don't do it as a formal matter, pre-clearing. If there's sometimes people will come in and they will have an actor and they're curious whether or not this actor, as identified on their paper, is ultimately owned or controlled by someone we've sanctioned. Folks will sometimes reach out to us, and informally we can try to provide a steer, but just having that information is often helpful. So kind of common sense rules is what I encourage.
Yeah, no, again, very similar to the UK. I think we've got an offence of circumvention in our legislation. I think it was in SAMLA, the Sanctions and Anti-Money Laundering Act, for a while now. And over the last 18 months of the Russia sanctions, increasingly the government and the international focus has moved from new designations to actually ensuring we're implementing and enforcing what we've already got, plugging gaps, and tackling circumvention and evasion are key parts of that. And trying to help companies identify where they might be vulnerable is a big part of that. The US has done a lot of advisories. We did one last year with the National Crime Agency, a red alert, we call it, rather kind of alarmingly. But the typologies in there are similar to what Brad described. Shell companies, often in secrecy jurisdictions. Also, moving assets to family members or known associates in an effort to obfuscate ownership, beneficial ownership. Looking at companies who are suddenly transacting in new markets or much higher volumes than they had done previously, or sort of way out of proportion to their balance sheet. All things that should trigger suspicion. I think that points to, particularly in a regime like Russia, where there is a lot of lack of transparency or doubt over who owns what, of actually just companies not just putting names into a sanctions screening tool, but undertaking appropriate due diligence, appropriate risk assessments on their potential exposure. Very similar for us. We're not going to prescribe exactly what good due diligence is. We've tried to set out some principles in our guidance. We hope to actually produce something similar over the next year or so to OFAC's principles of good compliance, best practices. I forget the exact terminology to help firms. But we're always going to look. We're not going to clobber people who have put in place appropriate due diligence, who have made best endeavours to avoid being, duped, as Brad said. And what's appropriate is ultimately going to depend on the sector the company is in, size of the company, their risk exposure, the context, and so on. So there's no sort of hard and fast rules. We always value cooperation, voluntary disclosure. So, in the UK, there's a legal obligation to report any suspected breaches of financial sanctions. We expect firms to do that. In our guidance, we're very clear that in any enforcement action we take, we'll put a high premium on voluntary disclosure, cooperation with us. So we're not after this sort of 90+% of firms who are trying to comply honestly here and are not turning a blind eye either willfully or otherwise to activity.
Yeah, and I think that in addition, you can already see that there's a more data-driven view on the field of how we are dealing with circumvention of sanctions. For example, recently the Dutch newspaper also reported that there are a lot of course, of the trades with Russia that stopped, but then the neighboring countries, Kyrgyzstan and Georgia, their transport grew with 88% and 69% respectively. So you can feel there's something going on around that, but at a little bit lower level within the company. If you have a company like trading a lot with Russia and your trades continue to trade on a similar level with other countries just surrounding Russia, then that's of course a red flag or even a black flag that something is going on. And sometimes you see that at the highest level, that the individuals there are not even aware that on a lower level maybe circumvention is taking place. Whereas as you see as you look at the data being available, at the continuous of turnover, whereas Russia export and transactions with Russia had stopped, you should have been aware that something was going on. And that's, I think, one of the most important things to check within a company previously acting with a lot of business partners in Russia. What is currently going on if you compare it with the trade volume before 24th of February 2022? What are we doing now? Are the potential risks there? How did I mitigate those risks? So not only like the high-level compliance risk analysis, but specifically looking into your transaction, into your turnover results, and setting up the internal controls. I think that will be very important. Also to show that you did all your compliance actions you could.
Absolutely. Well, I want to make sure to leave some time for specific questions. One topic that I thought it might be good to touch on before we do that, though, is just picking up on the theme of the targeted sanctions and the impact that those have primarily in the blocking of property and assets in whatever jurisdiction is doing the blocking. I think maybe last year on the panel we talked a little bit because there has been various initiatives in different jurisdictions to be able to actually seize the blocked property that's in various jurisdictions, and so I thought it might be interesting to get a little bit of an update on that front, if there's a clear path in any of these jurisdictions for what's happening with blocked property, if anything, other than simply having it maintained as blocked.
Well, I'll kick it off just as a pure legal matter, under sanctions as a very, very pure technical matter. Under most OFAC sanctions programs, assets are blocked, that's to say they're frozen. Only in the event of a declaration of war involving the United States, or if, let's say, essentially NATO obligations were triggered, could, under our authorities, OFAC seize assets and then transfer control. And that isn't quite where we are right now in Ukraine. We aren't formally in an armed conflict such that that traditional domestic authority has been triggered. That is not to say, though, that my colleagues at the Department of Justice aren't necessarily considering options under which, under existing criminal statutes, we can forfeit assets and then take possession of them. That actually happens with some regularity in the United States. Most commonly, you will see it in the Iran era with like tankers and oil that is at sea, but it happens with other programs. And so that's sort of an analytic framework with which we are approaching the current conflict with Ukraine. That said, domestically, if you look at our legislative initiatives, there is a big push from Congress to sort of think about authorities that might give us broader powers to capture assets in the United States. Candidly, if you look at the number of assets we have, a lot fled the US after 2014. And so if we look at the big numbers, the big statistics that are out there, they're actually located more in European jurisdictions. And so we, working with our colleagues at the home, justice ministries, finance ministries around the world, are collectively trying to think of ways in which we can leverage and perhaps ultimately put these immobilized, in some cases blocked assets to use in terms of the broader Ukraine effort. So it's a very much of an ongoing effort, and I would say it's being considered from a variety of different authorities. And technically, there's also some things we have to think about too, because we have a lot of assets that are immobilized, but under domestic law not blocked. So that's to say central bank assets. What we essentially have are prohibitions in place that say essentially you can't move them, but they aren't blocked, so they're not placed in what under our laws would be interest-bearing accounts. And so there's a lot of nuances here that we're thinking through, and all I can say is there are high-level and constant demand signals from our political leadership to find ways in which we can leverage those assets. And so I do not think that will be letting up at all in the coming months.
Yeah, no, absolutely. Again, very similar here, and I think if Kateryna was with us, she would make the point around the needs of reconstruction in Ukraine are immense, and there is a real desire, particularly here, to find ways to make Russia pay for that as the aggressor. As in the US, there's a very clear distinction between assets that are frozen and what you can seize, and under our sanctions regime, assets are frozen. They don't belong to the UK government. We can't seize them without legal recourse to do so, and broadly that could come from an international claim against Russia that is upheld and then pursued through the UK system, and UK assets are used to meet that. I know there are various efforts underway internationally to do that from the Ukrainian government and others, but that's what I'm probably about the only non-lawyer in the room, but the lawyers have a much better sense of how long that will take and its chances of success to come to fruition. Or domestically, similarly to in the US, if we can establish through an investigation that a criminal offence has taken place, that those assets are linked to, law enforcement can undertake seizure, forfeiture of those assets as they would for other proceeds of crime. But legally in the UK, we can't just say we're going to seize these assets because someone's been designated for an asset freeze. So what we have done, and was encapsulated in what we announced around the Ukraine Reconstruction Conference hosted in London in June. Is we amended our sanctions regime to enable us to keep Russian assets frozen until such point as Ukraine's territorial and political sovereignty is being restored. So, we're not going to necessarily seize these assets, but the Russians are not getting their hands on it, and that's 18 billion of frozen assets in the UK. There's also the central bank of Russia assets that are, as Brad said, technically immobilised rather than frozen. Overall, I think that the repo task force, Russian elite proxies and oligarchs international task force, has put out a notice saying there's over 250 billion of assets put beyond Russia's disposal at the moment. We've also set up a voluntary route where individuals who have got assets frozen in the UK are willing to, renounce the war, renounce the behaviours for which they've been designated, take various other actions, and voluntarily release this money for reconstruction in Ukraine. We're willing to enter into discussions on that. And we also continue to explore all avenues for using what we can legally do to seize assets where there's legal justification to do so to fund reconstruction in Ukraine.
Yeah, and that's also a topic you used back in the proposal for the directive, where member states shall take measures to enable freezing and confiscation of the instrumentalities and proceeds from the criminal offences included in the proposal for the directive. So you can imagine, for example, any steps to try to circumvent sanctions regulations in the broader scope, as I just mentioned. Those could be regarded as crimes for which you can take measures to confiscate those proceeds of crimes. So just accepting that you are designated UBO and accepting that your accounts are frozen, then of course there are limited possibilities, but taking action, trying to conceal the fact that you are a UBO, helping UBOs to conceal the fact, and all those kinds of actions may eventually be a reason just to not only to freeze it, but to confiscate it as proceeds of crime, namely the circumvention prohibition in the broader scope that will be implemented. So I'm very curious to see how that would work and how that will be used by the authorities.
Great. Okay, well, we do have a few minutes. I'm happy to take any questions here for the panel if there are specific questions. If not, I have a whole list of questions I can just Very back.
Hey there. Hey, can you hear me all right?
Yeah.
Hey there. I'm a reporter with a trade magazine called Global Investigations Review. Charles, you talked about enforcement cases taking a long time to work through the pipeline. I wonder if you could talk to what any of the pinch points are in that pipeline and whether the Defence Council can do anything to speed it up or perhaps even slow those cases down.
Well, I probably don't need to give people in the room lessons in slowing down the cases, so I won't attempt an answer to that. But look, as Brad described, I think a little bit earlier, there'll be various stages that we'll go through from becoming aware of a potential violation, either through a voluntary disclosure or through other sources that we've got. We've got extensive information-seeking powers that we can use to contact the firm or other firms involved to request information. We will then analyse that. That tends to be an iterative process. In terms of speeding things up, what obviously helps is providing as full information as possible. We want people to report in a timely fashion, to notify us as soon as reasonably possible of a suspected breach and to provide the fullest information they can at that point. But then also, as firms will often do their own investigations or will do their own investigations to respond to our requests and to provide us with the information we need as quickly as possible and as substantially as possible, so we don't get into a sort of endless iteration of, okay, thanks for this, but what about this? What about this? What about that? What about, what have you, So that can certainly help speed things up, but these things inevitably take time because both sides will seek legal counsel, will need to assemble information, and we will certainly try and progress cases as quickly as possible where they're simpler, or where that information is provided quicker, or frankly where they're high priority because of the severity or the importance or the nature of the case.
Yes.
In this morning's session with the DOJ and the SPO, there were quite a lot of cross-collaboration, people sitting in each other's teams to help information sharing. Do you have a similar structure in between?
Yeah, well, I think to kick that off, Brad's already mentioned it, but yeah, well, we do. I mean, we already had a very close relationship, but we've made that work, I think, hopefully even better by embedding people in each other's organisations. So just last week, I think it was, one of Brad's officers started a secondment, a detail in OFC. So she will be sat in OFC day to day, working on OFC business, but also helping us share information, establish links, learn about OFAC. And we're currently in the process of sending someone the other way to sit in OFAC. So, by the end of the year or early next year, we hope to have, mutual detailees, secondees in each other's organisations who are working on these issues day to day, as well as, we end up speaking to if not each other, our team speaking to each other weekly, if not more regularly across our organisations. So that is very much the intent and is underway.
Okay, yes.
Well, just a small follow-up point or question on that, just from the EU perspective. So it's really good to hear, I think, regulators sharing information and this collaboration, and there's so much alignment with the EU. I'm just wondering, is it more complicated to cooperate with the EU because each member state is responsible for enforcement, so it has its own enforcement powers rather than at commission level, or do you have good communication with the EU as well, just around how does that work?
I'll let Brad have first go at that. Cooperation with the EU is a more sensitive topic.
Oh, is it? Okay, sorry.
I'm happy to have a
I would say it's evolving. The partnership with the UK was further along before the recent events, and so it's kind of natural we're able to stand that up. With the EU, it's a little bit more of their sanctions regime, which has always been in place, but some of the implementation apparatus is coming online more and more. And so as a result, we're having more direct engagements with the EU writ large, but then also at individual member state levels, because certain governments are perhaps more focused on implementing domestic authorities for enforcement, or in some instances own domestic regimes that still line up with the EU. And so there are sort of bilateral discussions that we've had with different countries. You can imagine some of the larger ones in the EU are obviously focal points. Obviously France, Germany, the Dutch, candidly are ones we speak with quite a bit. And then others are sort of standing up regimes, the Czechs, for instance, where we're starting to have more direct dialogue as they kind of confront these issues for the first time. So it's evolving because there's a lot more different member state elements that so it can complicate it a little bit. The spirit certainly is there.
Yeah, no, I mean, I don't want to duck the question at all. I mean, actually, it's been a really fruitful area of cooperation for us with the European Union. We've done that bilaterally, we've done it trilaterally with the US, and we're building those links, and both bilaterally and multilaterally with the European Union. And there are various different stages of evolution underway. I mean, for instance, the Germans have just set up a huge new agency that will take on responsibility for sanctions, which is a really positive step. So I think that relationship is actually really close.
Great. Well, I'm mindful of the time. I think we're going to have to stop it there with questions. And I would just like to say thank you so much to everyone on the panel. We appreciate how intensely busy your schedules and demands are right now. So appreciate you carving out the time for us. So thank you so much.